Commissioners.
How are you?
I'm fine, thank you, sir.
Great. Tell me, where did you obtain your degree?
Sorry, I beg your pardon, Chief Justice?
Where did you obtain your first degree?
At that stage, University of Durban, Westville, as it was
Yes, when
known
was
then.
that?
1989.
The next one was in Zululand?
Durban Namlazi Campus, Zululand, 1998.
Yes. What have you been doing in the legal sphere over the years?
From the University of Durban, Westville, as it was then, I joined the Department of Justice in 87,
87.
prosecuted both in the district and regional court.
Where?
At Durban, Durban
Okay.
Magistrates Court.
Yes.
Then appointed to the bench in the district court 1st of June 1993. Then
Durban again.
Then 2000 acted regional court magistrate until appointed in 2006 permanently.
Let's take it in stages. When were you first appointed a magistrate?
1st June 1993.
93.
Yes, Chief Justice.
Where?
At Durban,
Yes.
Durban Magistrates Court.
Now, while you were there, did you do both civil and criminal or only one of the two?
At that point in time, we were allocated to do criminal work only.
Yes. Was it because there was no civil work?
No, there was civil work, but it branched out into the district court civil and the district court criminal.
Yes.
So we were allocated to do crime.
Was it a matter of choice or was it the decision of the leadership?
It was the decision of management at that stage. We did ask to do civil, but we were confined to do criminal work.
Yes. And then, as at the time you went to act in the regional court, had you not yet done civil?
That's correct, Chief Justice.
Okay. Tell us about your experience in the regional court.
In the regional court, primarily criminal work up until the time that the regional court was seized with criminal jurisdiction, or rather civil jurisdiction. Then we had the opportunity to do civil work in that regard, divorce matters, and the
Yes.
normal civil work.
When were you appointed to the regional court?
Around about April 6th, April 2006 permanently.
2006.
That's correct.
So all in all, if you combine your appointment to the regional court and the district court, you have been a magistrate for how long?
25 years.
25 years. And did you say you got to do some civil work as a regional court magistrate?
Yes, I did, Chief Justice.
Yes. And did that prepare you for your subsequent acting stint as a High Court judge?
Yes, it did, Chief Justice. We did. The divorce matters were more or less the same. Just the complexity of the civil work was different.
Yes. And are you settled? Are you comfortable in the High Court environment?
I think I am. I mean, I've been there in a total period of 9 months, if one counts from 2015
Sure.
up until
Yes.
1st April 2018. So I think I've settled down there.
And did you find yourself taking long to deliver reserve judgments or finalize part-head matters, or has that not been
No.
your experience?
Fortunately, I've managed to finish all the cases.
Yeah. And what is the longest it has ever taken you to deliver a reserve judgment in the High Court?
A week.
A week. And what is the largest number of part-head matters you've ever had as a regional court magistrate?
About 5.
And how long did the longest take to be finalized?
About 6 months.
Okay. If you really want to make a good impression, should I put it that way? To make sure that we don't inadvertently give less weight to what ought to work in your favor, what are the factors that you would want to highlight to demonstrate to us just how ready you are for the High Court?
I think the words that I would choose would be efficient, expeditious, in terms of the fact that I don't have any outstanding cases in the High Court. I finalize all the matters within the allocated time that have been in the High Court. I think efficiency would also come to mind in the sense that you start a matter, you want to finalize it as soon as you can. So we're proactive in getting the matter expedited as soon as we can.
Yes. Thank you. DJP?
Thank you, CJ. Mr. Maharaj, you have had several acting stints since 2015, as you have said, but AFT is of the view that you still need to develop further experience, more particularly in civil procedure. What's your comment?
Deputy Judge President, with respect, I would say that in the 9 months that I have been in the High Court, I think for 2 months we're totally devoted to civil. In the last 3 sessions, we did civil appeals, civil court work as well, motion court, case flow, civil trials, opposed motion. So I think I have the experience in terms of discharging the function, but not necessarily comparable to criminal work, where I spend most of my experience with.
Do you have any reason why AFT is the opinion that you still need a further
No,
experience?
I don't believe I do. I've learned and I can learn as I go along.
Further, the members of AFT have also expressed concern that you employ bodyguards to protect you while sitting as a judge. May you throw some light on this?
I have no knowledge of that. I think somebody is confusing me with somebody else. With respect, that doesn't apply to me.
In the light of the demographics of KwaZulu-Natal, would you say that your appointment will in any way advance transformation on the bench?
DJP, what I'd like to say is I'm alive to the provisions of Section 174, subsection 2, in terms of race and gender being as a factor to be considered in the appointments. From my side, I would say yes, in the sense that while I may be of Indian origin, I can't take that away. By being born in this country, I would say that I am South African, and proudly so. I don't see that as an impediment for appointment. So given the experience and given the level of work that I have done, I think I can be an asset to the High Court bench.
Is that how it will advance the transformation?
If transformation, you're referring to appointment of an Indian person because there are more Indian judges, then perhaps not. If it's referring to the fact that you need to appoint African male and female, then definitely that must take preference.
Okay. Are you in any way conversant with the customer law or customer legal tradition, so legal system?
Not entirely, besides what I've studied in the LLB degree in indigenous law, but I'm well aware that you did write a book concerning customary law.
Yes,
And
I'm
you're the
asking
author.
about you.
No, I don't know everything about customary. That's bare necessities. In terms of marriage, in terms of lobola, perhaps, yes. But I don't know all the customs, to be honest.
And we are aware that the courts are consistently required to develop customer law when the circumstances so demand. Are you aware of that?
Yes,
Have you ever
but I
come
haven't done a
across that?
case.
Okay. Thank you, Chief Justice.
Thank you, DJP. MEC?
Thank you, Chief Justice. My question is a follow-up on the DJP's question, is that over the 23 years of our democracy, transformation of the judiciary is still a challenge. If you look at the racial and gender demographics of KZN, how have you contributed over the years in your profession to ensure that there is progress in ensuring transformation? And also, KZN is a very rural province. Can you speak any indigenous language so that there is transformation as well?
Okay, thank you for your question. A lot of questions that you've asked, but I'll try to recall it as best as I can. In terms of transformation, from my side, what I would consider my contribution to transformation is at some point in time, I think from 1999 to 2001, 2003, 2002, I did lecture part-time basis at the Durban Mlazi campus for students who were interpreters, prosecutors who wanted to improve themselves. I was part of that, and most of them qualified, or all of them. In terms of trying to assist with transformation in the legal field, I've had the opportunity to author a book, Confident Criminal Litigation, which serves primarily for the young entrants to the legal profession. So I think that helps to empower them. In terms of the last question, whether I have learned any indigenous language, with respect, no, I haven't.
Thank you, MEC. Commissioner Nyambi? You, Commissioner Stock?
Yes.
I apologize. I apologize. Maybe I've been calling Commissioner Nyambi a lot. I apologize. Over to you, Commissioner
No,
Stock.
no, thank you very much, CJ. No, the apology is well accepted. I know normally there's that confusion because of the size of our heads. I've got a much bigger one than on Commissioner Nyambi.
I was afraid to be specific.
No, thank you very much, CJ. Good morning, Mr. Maharaj.
Morning, Commissioner.
All right, I would just like to bring your attention to the questionnaire which we have actually filled in. And then there's a section in the questionnaire that deals with any other relevant matter which you feel you might bring to the attention of the commission to consider for your appointment. Now, what happened there, you have actually indicated that there is information. You have ticked the yes, and then you have also attached an annexure to that particular effect. And then I want to bring your attention to the attention to that annexure, and it reads as follows: that on the 28th of January, the Office of the Director of Public Prosecutions in KwaZulu-Natal to charge yourself and Mr. Smith with the following offenses, namely fraud, theft, corruption, and defeating the ends of justice. So, Mr. Maharaj, in light of the annexure, I would just like you to take the commission to confidence as to what actually transpired and how was the matter resolved, and whether this matter was in actual fact taken on appeal or whether it has been settled.
No,
Thank you.
The charges were withdrawn in June of 2000 after representations were made to the Director of Public Prosecution. The charges arose out of the sentence which I had imposed in the district court as part of a condition of suspension. The authority that I used at that point in time, which I have with me, was the Transvaal decision, which said that in terms of 297, subsection HH, a court could impose any condition in terms of that provision that could be imposed was allowed. And if I may just read to you that particular provision so you have an idea that it was a judicial discretion that was applied. And the case I refer to is State versus Morstead. The citation is 1991, volume 1, SACR 636. It's a Transvaal case where the court held that a court had such a wide discretion in imposing conditions for suspension of sentences that virtually any condition which could be imposed was included. So at the end of the day, I imposed those sentences. The office of the DPP took a different view. When it was pointed out to them that, listen, this was part and parcel of the judicial process, they withdrew the charges. So there was nothing untoward in terms of any benefit or any of the children being at the creche or anything of that sort. So it was just a sentence that was imposed, and they believed that was a crime, which I disagreed with.
Now, my other question is that since the matter was resolved, the charges were withdrawn, Did you sue the state?
Yes,
or
I did.
Did you claim any damages to that particular effect?
Yes.
And what was the
The outcome was the judgment went against me. The court ruled that the state had acted reasonably. So if you want to put it in mild terms, I basically lost that case. So judgment went against me as the plaintiff.
Now, in the matter between yourself and the state, which came before Justice Kuhn,
That's correct.
and then I want to bring your attention to that judgment. It reads as follows. I'm just going to make a citation of and extrapolate part of the judgment, and it reads as follows. Even to the extent that the plaintiff might have been fortunate to have the charges against him withdrawn, because if during any trial against Mr. Smith, the plaintiff's evidence as to what Mr. Smith on his version allegedly told him was disbelieved, his complicity and would continue to exist, and hence also his status as potential accomplice. The state might in those circumstances have them remiss on that information not to continue against both Mr. Smith and the plaintiff, leaving any conflict between them to be resolved and decided in one forum. What's your comment in regard to this?
The fact that I didn't take that matter in appeal means that I've accepted the decision. Doesn't necessarily mean that, with respect, I agree with it. It's just that we didn't decide to take it in appeal. We accepted the decision.
Okay. Thank you, CJ.
Thank you, Commissioner Stock. Commissioner Singh?
Thank you very much, Chief Justice. Good morning, Mr. Maharaj.
Morning, Commissioner Singh.
The two questions that I wanted to ask have been answered by yourself, asked by the DJP and another commissioner, and that's on the question of what AFT had to say. But there's another matter that AFT referred to, and if I may read. Mr. Maharaj is a magistrate in the regional court. Members have raised concerns about Mr. Maharaj's temperament in proceedings before that court. Can you speak to that so we could understand why you think they would have
Commissioner
written
Singh,
that?
you must appreciate sometimes, as judicial officers, maybe you falter, maybe you're human, but in the fact is that you want to get your court started. My work ethic is that you must start at 9 o'clock. You want to be punctual. You want to have discipline in court. You want decorum of the court. And sometimes you may cross swords with people who come late for no apparent reason. You engage them on that. It's not a question of being personal with anybody, it's just a question of wanting to do the job. You employ to do a day's work. You need to engage for the day. And any disruptions or time that's wasted in court impacts on court productivity. So people are referring to temperament. Yes, sometimes you may be firm, but you're not trying to be personal with them. There's a purpose behind trying to be firm.
Did any of these members ever approach you about your temperament and how have you dealt with it?
That's the irony. You may have complaints in paper. No one has ever approached me either personally to say, listen, Mr. Maharaj, we think that you've been heavy-handed, or written something down on paper and given it to the regional court president or to the deputy judge president or to the judge president for that matter. I can understand that nobody wants to complain in writing, but at the end of the day, I don't believe that I've acted in such a way to insult someone just for no reason. It was merely trying to enforce discipline and punctuality.
Thank you, Chief Justice. We also heard earlier on in another interview about the Fridays that you spoke about, Chief Justice. Friday afternoons.
I'll come to it.
Oh, you come to that one. Okay, you can ask Mr. Maharaj. Thank you from my side.
Thank you, Commissioner Singh. Commissioner Masuku?
Thank you, Chief Justice. Good morning, Mr. Maharaj.
Morning, Commissioner.
Just following up on what Commissioner Singh asked you, the question is not really about trying to be firm. The question is about being blatantly rude. And I'll refer you to what the BLA says in its comment about you. It says, our main concern is that the Durban High Court, sitting as a court of appeal in the case of Nolubabalo Nomsuga versus the state, the learned judges Kruger and Stein made the following comments. The manner in which the learned magistrate, referring to Mr. Maharaj yourself, berated Dr. Hammond for arriving at court a few hours late, and the manner in which he treated Dr. Hammond is deplorable, to say the least. In my view, the learned magistrate was abrupt and rude and discourteous towards Dr. Hammond, whose evidence, as I have already stated, could not be faulted and was indeed corroborated by Dr. Hammond,
Dr. Hattie,
Dr. Harting. Your answer to Commissioner Singh is not completely an honest answer to your temperament.
no, with respect, I disagree. I'll tell you why.
Sorry, you disagree with what I've just read to you.
The judge of appeal made those comments. That particular case, Chief Justice, dealt with Domsuka, who was the mother of a child that was recently born, a newborn baby that was charged for murder of the child. That child was discarded in a bin bag. The paramedics who arrived at the scene found the child with marks on the neck. The post-mortem report that Dr. Hammond, as you refer to, conducted was far from satisfactory, in my opinion. Dr. Hammond was given many subpoenas to attend court. He was discourteous, he refused to come. Being a part-time district surgeon, he saw fit to give time to his practice. Eventually, after a few hours, he did come to court and he was asked why did he have to keep the court waiting. It's a serious matter. While the judges of appeal have expressed an opinion, I respect their opinion, but with respect, I disagree with that because I was seized with the matter in a live form with the trial. The judges of appeal, with respect, they're dealing with the matter on record. The judge may have made those comments. I accept that. I don't have an issue with that, but with respect, there's not much I can take it further. The judge made a comment, I accept it. But I don't believe that that case was held 6, 7 years ago, Namsuka. And obviously since then, you've matured. We judicial officers, as I said before, sometimes we falter, sometimes we be overly firm.
Just the last question. What would you consider are your weaknesses as a judge?
Sorry, I beg your pardon, sir?
What would you consider are your weaknesses as a judge and the type of thing you yourself have reflected on and would like to improve on?
Well, I think with time as you matured, you've been in the High Court. I don't believe there was any written complaint about my conduct to either the Judge President or the Deputy Judge President, and you can work on your demeanor, more or less. Perhaps not to take it too firmly in terms of trying to get your court started, to try to expedite matters.
Thank you, Chief. Thank you, Chief Justice.
Thank you
Mr.
so much. Thank you. Minister?
Good morning, Mr. Maharaja.
Morning,
Maharaj,
Commissioner.
sorry. Aft KZN's comment does not only relate to your conduct in court, but raises the question whether you are possessed of sufficient civil exposure. Now, in your questionnaire, on questions relating to your civil and other areas of the law, including constitutional law experience, you seem to respond by saying not applicable. Could that be because in your stint as a magistrate, including at the regional court level, you have never had exposure to civil work, even after the civil jurisdiction was introduced in the regional court?
When the civil jurisdiction was introduced, we did do civil work, primarily the divorce matters, concurrently with the criminal matters. The regional court then...
So it's only divorce that
No,
you've
no, no,
dealt
we
with?
did motion court, you did normal summary judgments, your normal civil trials, etc. But in terms to improve myself for civil work, in 2011, I took time off from work, 2 months leave, to sit in the High Court to learn how to do things, or how things are done in the High Court with Madam Justice Kate Pillay, who was kind enough to mentor to show how things done. When I got back...
My apologies to interject, but you see the form then is misleading, because in the form you say not applicable. What did you mean by that in your own form? Unless we have wrong information. If you are giving a narrative of the extent of your exposure in civil matters, as you have begun to do so, weren't you in 6.2, weren't you then supposed to have responded differently to the questionnaire? In other words, it appears to me that you're contradicting
Your mic is
yourself.
off. Your mic is off, Mr. Maharaj.
sorry.
Just keep it on.
Yeah.
Testing.
In other words, just to clarify, it appears to me that you're contradicting yourself between what you say on paper and the narrative you're providing us now. I mean, have I not asked you that question? I could have been left with an impression, I suppose, wrong impression in your view. Unless I'm missing something.
My understanding was, in the district court, we didn't get exposed to civil work. We did primarily criminal work. In the regional court, it was primarily criminal work. Subsequently, we did civil work. When I went to the High Court to be mentored by Madam Justice Pillay concerning how motion court is run, I then went back to the district court to preside in the civil court for a month or two, I think in July of 2011 or 2012. So when I wrote not applicable, I was referring to the fact that we didn't do it all the time, because the primarily function we had was criminal work. The most exposure to civil work was in the High Court. So,
But was the questionnaire, if I may, Chief Justice, limiting you in the manner that you seem to have limited yourself in hindsight?
in hindsight, I should have said I had, but in the CV, I did put that I was mentored by Madam Justice Pillay. So perhaps that should have been included in the civil experience.
In other words, what I'm trying to get through, Chief Justice, and my apologies for this follow-up, could it be that at the back of your mind, you don't quite see yourself as a civil lawyer unless you are prompted to say something about it, and that's where you feel perhaps you should share this information?
I think with respect, I would say that because my forte, if one can call it that, is in the field of criminal law, and you have less experience in civil work in terms of being exposed to civil work in the regional court, unless you go primarily to do civil work on a permanent basis, because the regional court runs on the regional civil court and the regional criminal court. I'm based in the regional criminal court. So as I said, the most exposure I have with civil work was when you went to the High Court.
And in the regional court, you never did any civil work?
No, we did civil work for 6 months.
Oh, okay. Thank you, Chief Justice.
Thank you, Minister. Commissioner Noke.
Thank you, Chief Justice. Mr. Maharaj, very recently, in the matter of economic freedom fighters versus the Speaker of Parliament and others, the Chief Justice of this country sounded or repeated a strong warning when he had this to say: the second judgment is a textbook case of judicial overreach. Now, having that statement in your mind, and also just before you answer, you also take into account what was said by Justice Froneman in the case of the Black Search versus the Minister of Social Development and SASSA. What is your understanding of the doctrine of separation of powers, and what are the judicial constraints that judges should maintain?
Thank you for the question. My understanding of separation of powers is based on the fact that you have the legislature, you have the executive, and you have the judiciary as the third branch of the state. Each functions in terms of legislation as to what concerns them. Insofar as judicial overreach is concerned, it's a question of whether the courts have the authority to dictate to Parliament as to how they should conduct their business. However, if it's a constitutional issue, if it's within the Constitution for the Constitutional Court to make that decision that they can direct how Parliament is to function, then I suppose that can't be judicial overreach. But my understanding is judicial overreach is simply that not entering into the arena of another space as to tell them how to discharge their functions.
Secondly, in your debate with the Deputy Judge President about the application of the customary law, I want to understand from you, if you are confronted with a situation where the application of customary law is called for, is it permissible for you as a judge to invoke the principles applicable to common law in resolving a customary law matter? And if you are saying it is permissible, why?
Well, if you look, your starting point would be the Constitution. Customary law which offends any of the rights in the Constitution, provided it's consistent with it, should be followed. If you have to apply customary law together with common law, provided you reach a just outcome, I don't have an issue with that. Or you can call witnesses who are experts in the field of customary law to come and assist the court in arriving at a fair decision.
What I'm trying to say is that is customary law and common law, according to you, at the same levels?
Yes, I would with respect say so.
Thank you, Chief Justice.
Thank you so much, Commissioner JSC. Commissioner Norman?
Thank you very much, Chief Justice. I've been covered on my questions.
Thank you. Commissioner Fourie?
Thank you, Chief Justice. Good morning, Mr. Maharaj.
Morning,
Here I
Commissioner.
am. Mr. Maharaj, in one of the judgments that you attach to your questionnaire, the judgment of Sabuta versus the state, that is an appeal that you heard in a rape case. Can you recall that matter?
Yes, I do.
That is a matter where the appellant raped a 7-year-old girl.
I think 9, it was 9.
The judgment says 7 years old. After kicking open the door of the homestead, and then the appellant took the complainant into the bedroom where he raped her, and he then took her out of the house into the yard, and he subsequently fled the scene. You dismissed the appeal in respect of the conviction, but in respect of the sentence, the appeal was upheld, and you interfered as the appeal court to reduce the sentence from a life imprisonment to 25 years imprisonment, with which I don't particularly have a quarrel with either, because I think in practice it more or less boils down to the same. But what I do have a problem with is that you say in your judgment, the following factors persuade me that substantial and compelling circumstances do in fact exist which justify the imposition of a lesser sentence. These factors are the following, and then you list 4 factors. But the second factor that you list is the one that's bothering me. And you say, the failure by the state to adduce evidence of the seriousness of the injuries to the complainant and how this has affected her emotional state. We're talking about a 7-year-old, and I'm just concerned that you regard that as a factor to be taken, and which you in fact took into consideration in imposing a lesser sentence. And I'm just asking you to amplify on that and explain to me why that should have been a factor at all.
Thank you. Thank you for your question. The Supreme Court of Appeal in State versus Vilakazi said precisely that you can take the fact that you decide a case of rape depending on the seriousness, whether it falls within the upper echelons of seriousness or not. One of the factors is the emotional state the nature of the injuries to the complainant. And the Supreme Court of Appeal held in that case that you could take that as a factor into account, which we did. You must also appreciate the fact that as an appeal judge,
Sorry, just to interrupt you, in the Supreme Court of Appeal case,
State versus Vilakazi,
what was the age of the complainant there?
12. And there's two judges sitting on appeal in the matter. I think that one was Judge Bezuidenhout as well. So it's not a question of one judge having his views as to whether the sentence ought to be reduced or not. It's a collaborative issue. You must also appreciate the Supreme Court of Appeal also held in State versus PB that substantial and compelling circumstances, the term is so elastic, it could include any mitigating factors. So we felt that that sentence ought to be ameliorated, and that's the reason for that. Not the fact that rape is any less serious. I think in the judgment I go on to say that rape is a despicable crime. It's just that we felt that life imprisonment wasn't warranted in that particular instance. That's as far as I can take it, sir.
I said I do agree
Oh, thank you.
with the
Thank you.
sentence, but
Yeah.
I have a difficulty with a 7-year-old complainant to use that as a factor to justify a lesser
I
sentence.
appreciate and acknowledge the difference, sir.
Thank you, Chief Justice.
Thank you, Commissioner Fourie. Commissioner Nkosi Thomas.
Thank you, Chief Justice. Good morning.
Morning, Commissioner.
I just have one question to you, Mr. Maharaj. Taking into account the following factors, that you have, as far as I could determine, no civil litigation experience, and that you are said to be intemperate and you're required to do work in the way you carry yourself as a judge in open court. You've seen what the BLA has said, and it has likened your manner as that which obtained in the pre-1994 era. Now, that is very serious, an assertion to make. And also the fact that you have acted only for a period of 7 months. Now, my question to you is, taking all of these factors cumulatively, would you still maintain that you are ready for judicial appointment?
Thank you for your question, ma'am. Just the last session wasn't included the last 2 months, from 29 January to 1st of April, so it make it not a year nor there, but total of 9 months. The point I wish to stress, Commissioner, is the fact that having been in the High Court, having discharged the functions of a judge in terms of the civil work, whether in motion court, whether in the civil trial, whether in the case law court, I have done the work. I take your point that perhaps it may not be as much experience in terms of criminal law, but must also appreciate the fact that sometimes when you're invited to the High Court, you are allocated to do crime, civil appeal, or motion court, or purely civil. So that decision as to what you will do in the High Court is based on either the Judge President or the Deputy Judge President as to where they would best utilize you. So in terms of the 9 months in total, 4 of those months included civil, 5 were criminal.
Yes, my question is, taking all of these factors cumulatively, do you consider yourself appropriately qualified, or you could use more time, acting time?
With respect, I believe that I am appropriately qualified to be appointed.
Mr. Maharaj, just a quick one in the interest of time. The regional court president has, according to your CV, requested you to preside in matters in various courts, in KZN, regional courts.
That's correct.
Did you come across any of those stations, for want of a better expression, where regional court magistrates are never there on Fridays or on a number of days in a week?
No, Chief Justice, with respect, no. I've been to all of those courts because the other
Even on Fridays?
Even on Fridays. Friday is a work day, Chief Justice. You have to work.
Well, I know. I visited one with the Judge President, and there was not a single regional court magistrate there, and we were reliably informed that it is practice.
No, I'm not aware
And
of
it's,
that.
I must say, it's one of the stations that you have been to. I've gone through this list. I
Yes.
see it's there. So,
I can't recall when that would happen, but normally if one has finalized one's role, one would leave. Perhaps 1 o'clock, 2 o'clock, depending on what's on your role.
while we were there, was it about 10 or earlier? Just around 10 o'clock. Not a single regional court magistrate. So
May I-
you don't know?
I don't know about that.
Very well,
Check.
you're excused, sir.
Thank you very much.